All
right. For more on these verdicts and the precedent they could set for big tech going forward, let's bring in Harvard Law School professor Glenn Cohen. Professor Cohen, great to have you with us. Thanks for being with us.
Thank you for having me.
How do you think about this in terms of precedent setting?
It's been a bad week for Meta for sure, and for YouTube to a lesser extent. On the one hand, we have this very large verdict in New Mexico, and there's more to come in that case regarding public nuisance. And then we have this one result in the Los Angeles case, but that's one of several thousand pieces of litigation that are being consolidated in a bellwether. A bellwether is supposed to give you a signal. It's not a great signal for Meta.
So you think there's more litigation to come? I mean, it's interesting because, you know, the stock reaction to the news, to the two verdicts, was pretty swift when it comes to Meta in particular. But the Wall Street community seems to want to defend Meta still and look through these cases and say these are small amounts, that there won't be further cases pursued because the payouts were so low that not many other plaintiffs' attorneys will want to join the effort. The payout's just not worth it. How do you see it?
I think the $6 million payout split between the two companies is significant enough to have people bring litigation. It's also going to increase the number demanded on settlement. Now, in Meta's defense, one argument they made that was rejected by the court, and the reason it got to trial, was they said they were immunized by Section 230. And there is this question about where the line between the design of the product, like something like infinite scroll on the one hand, and content is. And that line is one that's going to matter a lot for immunity to lawsuits, and I expect them to appeal that and maybe even go all the way to the Supreme Court. So they may lose a bunch of these cases and then ultimately get a ruling that Section 230 immunizes it and does the damage.
So, Glenn, it's Tim. First of all, thanks for joining us. It's a fascinating topic that you can opine on. Maybe who else is vulnerable here, especially, again, hiding behind Section 230 immunity, because this is something that probably a handful of companies that are north of $1 trillion in market cap could probably have some exposure to. Do you think this spreads beyond these two?
Yeah, well, I mean, Snap and TikTok were originally named in the Los Angeles case. They settled out. Snap, I think, because the liability for them, they're a small enough company that it's a significant number. TikTok, a little bit more complicated to understand exactly what they're thinking. But once they got a bad ruling on Section 230 from the judge, they decided to settle. I think those two companies, though, are going to be susceptible to a lot of litigation going forward, and certainly Meta and YouTube as well.
Professor, if they were to hire you, Meta were to hire you, and you were to agree to take the job, and they were to say, help us get in front of this entire situation, how would you advise them to do that?
So I think they have two routes. One, they want to win in the courts on the Section 230 arguments, and they're going to make those arguments on appeal. They're also going to push back on causation, about questions about whether this caused it on the one hand. But in terms of their public facing and in terms of the business story they want to tell, I think they want to tell a story about what they've been doing to make this safer for these populations and to talk about changes to features that they're making and why they take this seriously, because they don't want to look like public enemy number one when it comes to social media addiction.
Do you think this will change the way society views big tech? And I ask that question not because it's an interesting philosophical one, because it is. I mean, we are a business news channel. So I want to sort of understand whether or not you think there'll be more willingness, increased willingness for companies to go ahead with this, and also to press the representatives in Washington to do something about it. So there could be other guardrails being put in later on by the legislative route as opposed to just through the courts.
So two answers. One is just to say in the public consciousness, I think you brought this up earlier today in your broadcast, the fact that we're putting them alongside tobacco as a product is not a place they want to be in. This idea of a public health problem with like opioids, gambling, tobacco, and now social media is a very different framing from the one we've had before in the public consciousness. When it comes to governmental action, though, I would not hold my breath. I think Congress has been very slow to act in this space. I think it's complicated to actually rewrite the law in a way that will satisfy their constituents. And I think there's now an argument that if tort law is recompensing and giving punitive damages, why does Congress need to stop in? So I think some will be dissuaded from acting and rather have it play out in the courts.